Can you hear me, Judge?
Can you hear me, Judge? Okay, your phone dropped me. I have to stay on the cell phone to hear for some reason. Okay.
Okay, but the court can hear me now?
Yes.
Okay, great. It's in reference to position number 10, Mr. Can the court hear me? Are we ready?
Yes, I can hear you.
Mr. His accusation number is 23 CR 004900A. He's charged with harassing communications. The alleged incident date for his case is 7/26/2023. Today, during his first appearance bond hearing, there was some allegations or information about juvenile history record related to sexual charges that he was charged with, several charges that he was charged with. During this recitation of these charges, the court was in a live proceeding that was being broadcasted publicly. Additionally, the paperwork that was received for the charge this morning for harassing communications, as well as the pretrial report that the public defenders received, did not have any information that would possibly relate to, and that there were any sexual juvenile charges that would be spoken of publicly during his live hearing. As a result, we understand that this is a live hearing. It is equitable to people being present in court, and that matter has came and gone. We did object at some point, and the court did place us into a breakout room to further discuss the matter, which we appreciated from the court. But the amount of information that was put out live on public broadcast is now, once this session is completed, able to be posted and saved on YouTube and accessible to the public, thousands and millions of people. That is no longer equal to people appearing in court. Juvenile records are not accessible to the public. And so for someone to be able to pull up this YouTube live public hearing and to be able to hear the juvenile record of Mr. is a violation of his rights. And they should not have access to that. It will not only affect his possible education and schooling or college or anything else where he goes to apply for a job and his name is pulled up, and then they can pull up this hearing, and then they can see juvenile records that they do not have access to for charges they do not have access to. Furthermore, for safety purposes, anybody on the road publicly, anybody who has any feelings towards someone who is accused of these types of charges, who wishes to do harm to people for these types of charges, because this is no longer will be live, this will be saved for the public, can access this recording and see the charges that they normally would not have access to. And so we are saying that the saved recording and the public posting of this recording puts the information about Mr. juvenile history in a different posture than it would be if it was just live. And now we are posting information to the public that the public is not entitled to see or have access to. And so we are requesting that the court, for that period of time in which the ASG went through the specific sexual history related to the juvenile record of Mr. Nava silences that part of the hearing so that it is not broadcasted publicly indefinitely to thousands or possibly millions of future viewers who has access to these recordings. We do understand that the Constitution allows for public hearings, and we do believe that the live proceeding of these hearings have done that, but we do believe that public hearings and saved hearings posted on the internet are not the same and equal nature. And so we are asking for the court to take that curative nature of silencing that portion of this hearing before this is publicly posted to the YouTube page of the Fulton County Department or whichever page that it is posted on.
And Your Honor, if I could
All
respond,
right.
please.
State.
First, I'd like to point out, well, first I'm asking that you deny the request, and these are the reasons why. First off, the defendant did not waive his presence. We do not have a waiver on file, so it's inappropriate to even have another hearing about this without him being present. Second off, the objection is not timely. Third off, under OCGA 15-11-703, juvenile records are admissible at bond hearings. This is a bond hearing, and all hearings in Fulton County are open to the public. And lastly, it's not his juvenile record that was put on the record. He's charged with statutory rape as an adult. Let's be very clear. That's not juvenile record. He is 18 years old. There was no juvenile record put on the record. He's charged as an adult. So that defeats counsel's whole argument. Oh, this is a juvenile record and shouldn't be able to be broadcasted. Well, newsflash, it's not a juvenile record. He's charged with statutory rape as an adult. He's 18 years old. And lastly, there's no legal basis. So for all those reasons, I'm asking the court to deny the request.
And I just want to be clear for the record that I thought I heard the ASG said juvenile record. And so that's a correction if I'm wrong. I thought that's what I heard.
He went to felony first appearance today. And as of today, he's 18 years old.
I'm just saying when the charges were read, I thought what I heard from the ASG was she said that these were juvenile charges.
I'm not showing a juvenile record. I'm showing open statutory
my
record.
argument is the same. I'm just saying that's the only reason I said juvenile.
Well, that was the whole basis of your argument, that juvenile records are not accessible to the public. It's not a juvenile record. So the argument is not the same. Well, and it's not founded.
Well, now, either way, this is a hearing that's going to be published on YouTube.
Open hearing, correct.
And we do not believe, based on the nature of the charges, juvenile record or not, that this is something that the public should have access to permanently to go back and to be able to review for someone who is accused and charged of this. This is outside the realm of public.
Frankly, that's your opinion. Your opinion is not.
And I'm just making the record. I'm just making the record.
Your opinion is not based on law.
I'm just making the record. It is outside of the realm and access of public access to hearings. Now we are publicly posting records on a virtual forum and submitting them to the internet indefinitely to be viewed by anyone who wants to view the case. And so if he moves forward and his case is adjudicated as a first offender and this is taken off of his record and the public is not supposed to have access to that, he's supposed to be able to say he's never been convicted of a crime.
Again,
and this
you're
is
wrong
publicly,
because the postings
and this is publicly posted
for 2
then
weeks.
The public will have access to what is no longer supposed to be a conviction or something that is viewable on
his record. That would be the case for anyone in court. And when they're sentenced to first offender, their history is already read, it's already there. And then they what happens is really, all of that same information is discussed and read in court. Then the court decides whether to accept their first offender plea. They do, but then the court reporter doesn't say that I'm going to X all that out because of first offender. It's just when his criminal history is ran, when he later goes for a job after he's completed first offender, they won't be able to see it. But someone could be sitting in the courtroom, as Mr. Walker stated, and hear all of that prior to the court ruling on whether he gets first offender.
And Your Honor, we acknowledge that. We are saying the
And they could
virtual
post and do the same thing.
the virtual nature and posting online of this is what we are saying makes the difference between somebody sitting in court, hearing it live and knowing that, versus it being published online indefinitely, where someone has access to, where the entire public has access to indefinitely. We are saying that is the difference between people who can walk in court or look at this live. Everyone has heard it live, but when you post it online and you make it permanent online, then it turns into it's a different question and it's a different posture. And that is our only argument.
It's the responsibility of the clerk to keep
I
records.
do understand you.
You can walk into the clerk's
But I
office and request
believe there was, it sounds like there was a mistake made by saying it was his juvenile history when it wasn't. It was his felony first appearance information. Is that correct, Mr. Walker?
That's correct.
That's
Okay.
correct. And we acknowledge that mistake, Your Honor. Again, I said I thought what I heard from the ASG was that it was juvenile. So that mistake is acknowledged on my behalf.
So if it's not his juvenile history, but it's his felony history,
Then it
that
is then it is
what?
the posting that we are objecting to on YouTube, this being posted virtually online indefinitely is the part that we are objecting to, because we understand that it's not a juvenile record, so people can, it's the access. We are saying that because it's being posted and it's going to be accessible, it is outside the realm of a live public hearing where people just can go and sit and listen to something. Now that it's being published online, if he has first offender, people can go back into this saved online history and pull up this video and see that he was charged with these charges.
But
And
won't this happen on any case? And I don't mean to cut you off to be, I mean, I'm a former prosecutor myself, and I've never heard anyone make that argument, because those things are always stated in open court, and people can bring their phones and still record. We don't know because they don't take the phones from him. And I don't know that that part of your argument to me makes sense, that if he gets first offender later, it will be out there in the universe.
Well,
Michael, Mr. Jordan?
I mean, I don't understand what the whole argument is.
The
If
issue,
we
Your
are
Honor,
arguing a procedural argument today, I don't even think that's for today's count. See, if you're talking about first offender, somebody getting first offender later on down the line, and us removing something from off a YouTube live stream, because it's right now, it's already out on YouTube.
the
If he gets first offender later.
The first offender is an example. What we are saying is this should not be published and saved online. This is not the same thing as somebody coming and sitting in court.
So then that's not an argument for today. That sounds like something.
That is an argument for today, because once the court is over, this is going to be published online.
It's already being published online.
It's already,
No,
because it
it's
was
live
streamed.
right. It's live right now because we're still in court, but it's going to be actually saved.
But what is your argument today
In.
to say that you don't want to save online today?
We are saying that we do not want this published online. Is
Today.
what we're saying. We don't want this that.
So that is
portion of
the
recording.
Judge Macy didn't make that decision. That decision was made by our court administration. So that's what I'm saying to you. If you don't want any of these SEA hearings being broadcasted online and saved online, if you don't want any of the SAP hearings being broadcast and saved online, that is something you need to take up with administration.
We
And
are
I
just
think it should
putting
be
our
in the form of a
objection.
motion for this particular court, but this, and actually I don't know that we would have the ability to delete it or take it down later, I guess, outside of a court order, because it was live streamed,
We're just
not
putting our.
saved, recorded, and uploaded for later.
But
Yeah, we have
it's
rights.
going to be saved. We're just putting our objection that we have objected to this being posted and saved online and accessed for later. We could not object to it being live streamed. That's already done. We're just saying for it to be posted, we are objecting to that portion of it being posted online for everyone to see later on. That is all we're objecting
Okay, so we
to.
take this down and his felony first appearance is still online on YouTube. So then what? They're gonna go
You
watch
said-
that.
You
We can
said
take,
what?
I'm not agreeing, but you want us to take this down, but then the felony first appearance is still on YouTube.
Yeah,
So then
it's
what?
gonna be
It's-
heard over there.
We're just
correct?
objecting for our client. We're not agreeing that it should be. This shouldn't be
Oh, well,
streamed
you gonna
online
give your own
because the
objection,
courts
then
are
what?
open. We're just objecting per client. This is the client for today who's dealing with this matter, who information was given out during this hearing. So for today, we're saying that portion of this video, we are objecting to that sound portion being.
But Michael, don't
saved
you,
and
you have
posted.
to go back, when you go back to look at court from last week or the week before, do you have the ability to not post that, or does it go automatically?
So
Because it was recorded.
it saves automatically, but as the managers of the account, we can not post anything on YouTube that we don't want people to be.
Mhm.
Like I could go on there right now as soon as this thing save and not allow access to the video.
Mm-hmm. But I do believe it would have to be in the form of a motion to be reviewed. I don't know that I would just summarily do it, because I don't see it different from any of the other trillions of cases that I've heard since 2020, since being sworn in and
And
starting
Your
this
Honor, we
hearing.
understand that
We've
we
had
can prepare a motion.
similar issues and matters and cases. I mean, Mr. Walker's aware as well, and I think we would set a terrible precedent if we, based on your oral motion, did this. It may be something that needs to be heard and addressed in a written motion. I'd like to see some statutes and law for it. I don't know, sound like it's a round table for the solicitor and the clerk and everybody else and the chief judge, because I don't know. I hear you. I understand your concern, but I think every other defendant in similar situations would have the same concern. And I don't know how you go back and do that. If he gets first offender on it, again, when he goes to apply for jobs in colleges and he completes his first offender, it won't be discoverable, and it won't be brought up in the background check. Isn't that right, Mr. Walker?
Well,
Certain
Google
employers,
lives forever,
depending
so
on their
always
ability
find-
of what kind of background check they're
You
doing.
can correct them. You can always find criminal records online. So even if you take first offender, you can Google someone's name and see what they've been charged with. So I'm not sure.
And we can prepare, we understand that, Judge, we can prepare a written motion, and I'll have that conversation with my supervisor. I had it very briefly with him, and I do believe you are right as far as we need to take this up with, it's gonna be a round table type of thing. But we will look into preparing that motion. But I do want to say this last very thing, and according to what you just said.
Is your supervisor Mr. Howard? or
Mr.
someone else?
Howard, yes, Your Honor,
Okay.
and Miss Jinks. And it may not be it shouldn't be pull-upable, their record, if it's first offender. But if these things are continue to be published online the way they are, the same thing that's not supposed to be pull up, they can pull up during these video hearings or these virtual hearings online. And that's what we're saying, that's gonna be an issue. And so, but we will file a motion, if after I talk to my supervisor, if they think that that is the best course of action. We just wanted to make a note for the record.
Just to be clear,
Okay.
that's not the way first offender works. Even if you get first offender and you complete it successfully, you still have to file an additional motion to have the public record sealed.
Or
So-
you can have it sealed at the
Right,
time
no,
of the
but even
plea.
if you get first offender, you still have to file that motion to have your record sealed. So if someone goes through the process of getting first offender and then files a motion to have it sealed, then maybe you would have a conversation. But right now, no one's taking a plea to first offender. A motion has not been filed to seal the public record. And until then, I think we're talking about the cost of tea in China.
You would
I'm
think that,
trying
'cause
to
you don't-
hear
it's not-
and
it
find
wouldn't
out if
affect
there's
you.
any prejudice
So
or
he's not
harm
acting in
that
crime.
is coming to the defendant. And what is the prejudice or harm to this defendant versus the trillions of others? What is different about this one versus
We
any of
don't
the other
believe there is
similar
a difference,
cases that
Your
we've
Honor.
had?
We don't believe
that
there
we've
is a difference.
discussed in
We
the
just
past.
think that we haven't been addressing it, and I think we're gonna address it now. But
That's-
we will
okay.
have that conversation with our
Okay.
supervisors.
Yes.
Okay,
Thank
okay.
you.
All right. You're welcome. Thank you.
Okay, now that we have gotten all of that out, can we go over the calendar?
Yes.
Yes, ma'am.